here to tell you about a very significant lawsuit that we are involved with right now. The significance of this will apply to almost everyone in the freedom movement for various reasons. Now, we call this the case of the principle without principle, and you're going to find out exactly why. Right here we have the lawsuit. This is what we call the complaint. And on this complaint, as you will see, it was filed on March the 6th of 2006. The lawsuit was for $1 million. Now, at the time, we thought that was a bit optimistic, but of late, we're actually seeing that as more realistic as time goes on. We've specifically filed this in federal court because we do not trust the local and state courts. And you can see here the parties to the lawsuit are 4 of us that are associated with the freedom movement, with the Southern Heritage, and with the Patriot Network. The defendants in this case is Miss Brenda Kelly, the former principal of the middle school, Gary Stepp, her supervisor, all of the board members, the school board members, the district attorney, his assistant, and the newspaper, the Toccoa Record. Now, the newspaper is essentially a nominal party. We're not looking to get an award from them, but we did name them as part of the lawsuit in order to get their testimony. Now, the charges are basically this. We are focusing in on outrageous conduct on the part of the middle school principal, Brenda Kelly. Now, the others here are listed basically as a legal concept called respondent superior, which basically says that you're responsible for your subordinates. We included the DA because we felt the DA was not doing their job. And basically the issues are libel, slander, defamation plus, and violation of our basic civil rights. Now, mind you, this complaint, as well as every aspect of the lawsuit, is available on www.patriotnetwork.info. Why the lawsuit? Now, let me just give you a background. We had 60 of us, that is, had a rally out in front of the middle school. The purpose of that rally was after the middle school principal, Brenda Kelly, allegedly decided to ban the Confederate flag. Well, we basically exercised our First Amendment right to be out there and peaceably protest. Well, it wasn't very long after that, the very next issue of the Toccoa Record, in fact, when we saw this as the headline. Now, mind you, you have a picture of the Brenda Kelly right here. It says, Middle School Quiet Monday, Principal Receives Death Threat. And when our group saw this, we were like, wow. We were in shock. And we started looking around and said, who would do this? We're not this wacko group. And I guess we decided every organization must have its fringe people, and there were 60 people at the event. We don't know each and every one of those people. So we decided to give it time. We'd give it time, and whoever this was would no doubt be caught. It was very unlikely that they're associated with us, and we'd be vindicated. Well, time went on. And by the way, let me read page A3 to you. It says this: Kelly said she recently received the following anonymous email. Here I come. The time is near. Put the flag back, and I will not kill you in your office. Pretty significant. That's a death threat. There's no doubt about it. Well, time went on, and I decided to take myself down to the local sheriff's office. And I walked in, I said, so, how's the investigation going? And they said, what investigation? And I said, the investigation of the death threat. They said, What death threat? I said, hold on here. There was a death threat at the middle school. Then you thought, well, they didn't have a clue. So I finally said, can I see the police report of the death threat? Well, guess what? There is no police report of the death threat. Now, if you're like us, you're saying, something suspicious here. In fact, you might be saying something is rotten in Toccoa. So, our organization, the Patriot Network, and the group affiliated with it, decided to go through the initial steps. That's really the initial steps to any lawsuit. And it's a procedure called administrative remedy. If you've ever taken Clarkson's law course, you would know that this is part of the process. And that is, you basically go to the party that you believe has wronged you, and you ask them questions, and you try to work something out ahead of time before it ever has to go to court. Well, we sent in a few letters to the Brenda Kelly and to the school board to ask them some very simple questions. And it wasn't very long before, guess what? The Toccoa Record produced this paper. Deputies investigate letters harassment. And once again, you see her picture again, right there. And what this article basically says is that she decided to call our letters of calling for administrative remedy as harassment, and she called the police to investigate it. Now, this is kind of funny to me because the sheriff was basically getting the very same questions. And to this date, Miss Brenda Kelly has never, ever told us which question she found to be harassing. If she just simply answered our questions, we wouldn't have had to take it any further than that. So it was very revealing. And what this Toccoa record shows is that she does have the ability to notify the police when she wants to. Okay, so to this date, the only organization that we can verify that she notified in order to contact somebody about this death threat is the local newspaper. We have been through all the law enforcement, from the GBI, the FBI, to the local sheriffs, to the local police. Nobody has a clue about this. Like I said, something is rotten in Toccoa. Not even her supervisor was aware of this, although he kind of changed his testimony later. The lawsuit. Mind you, it is 1 year later. 1 year minus a few days, and we still have not answered the essential questions. We still have not gotten to the core of the issue. We started off many years, about a year ago, with something called the discovery process. And in this discovery process, by the way, this is what the school board, or the lawyers representing the school, provided us as part of their discovery. There's a lot in here. Mind you, this is all paid for by taxpayer dollars. Of course, there's only one paper in here that's really of any relevance. And that paper would be right here. And here is an alleged email that contains a death threat. It's from this Lexi Sabota, and the subject is, "I'm going to kill you for the flag back. Here I come, the time is near." Put the flag back just like the newspaper said. Well, we have problems with this. And the problems are simply that it's not email. It's a piece of paper, and quite frankly, it could have been produced on a word processor. We simply don't know, and we would like some answers. Now, to give you an idea, this is not what a death threat email looks like. An email looks like this, to give you a basic concept, and this is going to be too complicated for you to really, for most people to understand. But keep in mind that we have all this information right here. And this information shows you the time and date that the email was received, and basically all the different servers that the email hopped over in order to get from one place to the other. And this is just a sample email that I'm providing you here with, just to show you what an email looks like. Now, Miss Brenda Kelly never, ever made the claim that she received a death threat memo. What she said is that she received a death threat email. And we are still waiting 1 year later to receive and to give proof that she received a death threat email. The significance is this, and the fact is we decided, or we believe, that what she exhibited was outrageous behavior. She was embarrassed when the Southern Heritage people showed up outside her school. So what did she do? She decided that she was going to embarrass us. And the way that she decided to embarrass us was to conjure up a death threat. Now, the reason why that is so significant to a lawsuit is that if that death threat was real, then she has truth on her side, and we wouldn't have the same allegations of outrageous behavior. Bottom line is we've notified them on many different occasions. Said just simply show us the email and we're going to walk away from here for pennies on a dollar. Well, 1 year later, and it simply has not happened. These people, the lawyers representing your local school board and Miss Brenda Kelly has never furnished us with a death threat email. Now, we've gone to the lawyers back and forth, and I want to show you this right here. You might have to zoom in on this just to have proof here. We asked the questions. We said, look, we're not satisfied with a paper copy. We want to see the electronic version of this alleged death threat email. And here the lawyers are saying, and this is signed by Angela Hurley, we do not have electronic copies. Well, we all found that to be rather interesting and rather, rather peculiar, because let's go back to this piece of paper that is supposed to be an alleged death threat email. And if you notice at the very bottom, it has file, F:\\documents\learning environment \, and basically the subject line of the memo, and very significantly, a .htm. Well, if they have this file, then they have the electronic version, and it exists. So why won't they give it up? Well, we have a theory. We have a theory that if they did give us the email, presuming that exists, that it would actually hurt their case, not help it. The second mistake the lawyers have made, these lawyers representing the school board have made, is that they made mention that they received a CD-ROM from Miss Brenda Kelly. Now, if that CD-ROM exists, then once again, we have the electronic, or they have the electronic versions. So, make us a copy. Yeah, come on, we're talking about, what, 25 cents for a blank CD-ROM? It's insignificant. Insignificant. And all of this time, we still have not received that header information showing the different hops that the email took. And in the words of Shakespeare, methinks she doth protest too much. As Robert Clarkson has brought it out, if she forged this email, somebody is going to go to jail. This is something that is a very serious crime. It's obstruction of justice, nothing less. A very important principle with lawsuits is a principle called every man's evidence. And that is, the bottom line is that in federal court and Georgia court, there is no such thing as a civil trial by ambush. And that it's a straight out principle with lawsuits. You have to lay all your evidence cards out on the table prior to going to trial. And this way, nobody's taken by surprise. Everyone can have access to the same information and work it out. Hopefully prior to going to trial. But at least nobody can say that they were ambushed in the trial. Well, the problem goes on is that the opposing attorneys, the defense attorneys, have made it very, very clear that they're not going to give us any more information than we already have. Well, ordinarily that might provide a difficult situation in another case. But in our case, it actually helps our case. And here's why. See, we have them in a catch-22. The bottom line is that no header information proves that there was no investigation. And you must know that law enforcement has to keep meticulous records. So all they would have to do is go back to law enforcement and say, look, could we get the header information of the email we gave you in 2004? And they should be able to provide it. If they can't do that, that means they never went to law enforcement. Like I said, the only evidence that the only organization Miss Brenda Kelly notified was the local newspaper. Now, which is the greater example of outrageous conduct? Lying about receiving a death threat? Making it up out of thin air just to embarrass your adversaries? Or getting a real death threat and never reporting it to the law? And never making sure that there are 1,200 students that are safe. Now, mind you, that death threat said very, very clearly that it would take place in her office. If, I presume it'd be a gun. If a gun was used, there are ricocheting bullets. There are 1,200 lives of children that are endangered. Why wasn't this investigated? That is the question that we ask even today, 1 year later after we filed the lawsuit. In addition, I have to say I've learned quite a bit along the way and acting as pro se for this lawsuit. And among the things that I learned is school officials have immunity from lawsuit, from civil lawsuit. That's incredible. Now, it's true that it's a limited immunity. And in our case, their immunity does not apply, because all one has to do to strip away that immunity is prove malice, which is very clear in our case. But in many other cases, if you're arguing with the teacher about a curriculum, the bottom line is you have no choices, you have no options, you cannot sue the local school board on such issues. And for that reason, there's virtually no accountability involved here. And if there was ever a reason to keep your kids away from public school, that would be it right there. And that is, your teachers, your principals, everyone involved is not accountable to you or to anyone else. These officials continue to hide behind what I call the veil of immunity. And 1 year later, most of this lawsuit has been involved with just overcoming the various hurdles like immunity. Just before we can get to the actual core of the issue. Now, and the core of the issue is simply this: did this principal manufacture a death threat in order to embarrass her adversaries? Well, we think that she did. In fact, we think that lying has basically been her lifestyle. And sad to say, that is how you go up the bureaucratic ladder, is you lie and you beat people who dare oppose you. Number two that I learned along the way of doing this lawsuit is that witnesses have near absolute immunity. And there are cases where people can lie under oath on the witness stand, and they're immune, essentially immune. a very small window, basically. But for the most part, they can manufacture things, and they are still immune. It's a matter of depending on the prosecutor to prosecute a witness that has given false testimony under oath. And unfortunately, I believe that the prosecutors don't do their duty in that way. The third thing that I want everyone to be aware of, and this is perhaps the most significant, is that prosecutors, that is, the district attorneys, have absolute immunity. That word is absolute. And as their role in prosecuting a case, they have something the courts call quasi-judicial immunity. And they basically, I call it the Iron Curtain of immunity, because they can hide behind it, and basically you can think of the worst case scenario. They can manufacture and trump up charges, and it could be revealed it's entirely false, and they still walk. I mean, there's nothing to hold them back from doing so. And in fact, if you have been attuned to the newspapers of late, whether we're talking about the Duke University lacrosse case, or whether we're talking about the Border Patrol issue down in Texas, in both cases, the prosecutor has gone overboard, and there's simply no way to restrain that prosecutor. The prosecutor has no accountability to the people. In doing this case, by the way, we were able to find a loophole specific to our case. That loophole is that in the case of Imbler versus Postman, where the Supreme Court basically gave prosecutors this quasi-judicial immunity, they what we discovered is that in our situation, we found a loophole. In the case of Imbler versus Postman, when the Supreme Court gave prosecutors immunity, they said at the very end, we only give them immunity in the prosecutorial role. We do not necessarily make a decision today on their investigative role. Well, that fit our case like a shoe-in. That fit our case to a T, because that's our situation here. Is the DA failed to investigate a death threat. Well, I put together, right here, is a 26-page motion that I pray will make it to the Supreme Court. And at the very end of the motion, I asked them, overturn Imbler versus Postman. Please overturn it, because it isn't right. And obviously this is too long to represent to give you a fair analysis of what's inside of here. I'll just bring you one particular point that I bring up. And this is kind of a synopsis of the entire motion. I say, no one should be granted absolute immunity. That concept should be foreign on American soil. To do so ignores the fallibility, that is, the sinfulness of man in his natural state. The sinfulness/selfishness of man cannot be separated from the man. To do so would be to elevate a man to the level of God, which is, for starters, extreme arrogance. For second, it is deifying the district attorneys. This is offensive to true Christians who can have no other king but Jesus. It is a breach in this wall of this court. It is a breach in the wall this court insists must separate church and state, excluding one set of religious beliefs at the inclusion of another. So there you have it. I've asked them to overturn this case. If you want more information, it all can be found at www.patriotnetwork.info. You find the term lawsuits in the left-hand column, click on it, and that will take you directly to our lawsuit. and there you will find all the details associated with this case. Thank you.